So, by way of overview, what we're going to cover? Well, we're going to start with looking at the Civil Procedure Rules Part 14.1, which looks at admissions of liability. And in particular, we're going to look at Practice Direction 7 to CPR 14.1. Now, Practice Direction 7 focuses in particular on withdrawals of admissions of liability. 14.1 governs admissions of liability. So we'll look at those closely, and in particular, the criteria that the courts consider under Practice Direction 7 when considering whether to permit a withdrawal of liability admissions. Then we're going to look at, faced with an admission of liability, what do we do next? So we have an admission of liability. What practical steps can we do next? We'll look at tactical considerations when we then face an application to withdraw. Do you oppose the application to withdraw, or do you consent? In litigation, really, we don't fight battles we know we'll lose. So we really need to give careful consideration when facing an application as to how we proceed, because if we're going to lose that application and the court is likely to allow that withdrawal, then we need to give really serious consideration as to whether it's something that we want to consent to. Now, I said that I'd look at really what we should include in witness statements, but let's look at what we shouldn't include. So what are some don'ts? What should we avoid in witness statements? Well, I mentioned it in the last slide. Comprehensive is good in your witness statement. War and peace isn't. A judge who has an hour's application in the hearing before him or her and then gets a 40 or 50 page witness statement is not going to take too kindly to that. So focus your statement on the facts. Remember, a witness statement in these circumstances is not lengthy legal submissions. A witness statement is a witness statement of facts. So don't throw everything at it. Don't throw lengthy legal submissions. Focus on the facts, how they are applicable to PD7. I've said already, don't assume the judge will know the case. Explain what's happened since the admission. And don't be brief on detail, which goes to conduct and prejudice, which may be the most important points for you. And I'd also say don't be overly emotional. So I mentioned it's devastating for a claimant if the admission is withdrawn. Of course it is, but the statement's not a place to set that out. There's no place for, I think, strong emotive language in the witness statements to say, well, the claimant will be very upset, the claimant will be hugely devastated at this, because the emotion isn't in PD7, it's the administration of justice, it's prejudice, it's conduct. It's not the feelings of the claimant, unfortunately, of course.